Justice costs as much as it does for two main reasons. Firstly, because its practitioners have absolute control over the system that provides it, and secondly, because it's deliberately intended that ordinary people should not be able to access the judicial process. Lawyers are involved in writing the law, and then they're involved in interpreting, debating, and deciding it. In other words, they operate a complete monopoly on the provision of justice. And the first purpose of that monopoly, like any other, is to maximize profit for itself. Dickens knew about this almost 200 years ago and satirized it many times in his writing. In his superb book Bleak House, which is mainly about the British legal system, he wrote that the one great principle of the English law is to make business for itself. There is no other principle distinctly, certainly, and consistently maintained through all its narrow turnings. So as far as the administrators of British justice are concerned, providing justice is a very distant secondary consideration to making profit for themselves. Providing justice for people who have little money is not cost-effective to the monopoly. Therefore, it seldom happens. In his superb book, The Condition of the Working Class in England, Friedrich Engels touches on the interesting story of the Chartist solicitor W.P. Roberts, who made quite a name for himself in the 19th century, defending the working class in courtrooms throughout the country, as well as for his considerable efforts promoting the Chartist cause. So effective was Roberts in a courtroom that prisoners were sometimes released just on the rumour that he was going to defend them. According to Engels, Roberts began to be a terror to the mine owners. In Preston, 4 of his clients were in jail. In the first week of January, he proceeded thither to investigate the case, but found, when he arrived, the condemned all released before the expiration of their sentence. Almost everywhere Roberts appeared, people who had been charged with all manner of crimes and legally imprisoned suddenly won their freedom. But the great W.P. Roberts didn't come cheap. He cost the Chartists £1,200 a year. And remember, this was at a time when an ordinary worker was quite fortunate if he was making a mere £15 a year. There are a couple of relevant points to this story. Firstly, the body of laws themselves, which so oppressed the working classes, were so feeble that whenever any sort of robust defence against them was offered, such as that provided by W.P. Roberts, they simply crumbled and fell apart. In other words, the laws that were being used to justify this tyranny were routinely abused by all the officials concerned, from those making the arrests to the magistrates and judges presiding over the subsequent court cases. Roberts was called upon all over the country. There was not simply the odd case of rough justice occurring in some distant backwater. It was happening everywhere. Then, of course, there's the fact of Roberts' fee. No doubt he overturned many wrongful imprisonments. But for every quash charge that Roberts secured for his clients, how many other people who could not afford the likes of Mr. Roberts were convicted? There were tens of thousands of people who could not afford a proper defence barrister and who had no choice but to endure the same sentences from which Roberts' clients were being released wherever he appeared. Just how many of these cases there must have been can only be guessed at. Needless to say, the provision of justice should not be something that's wholly dependent on expensive lawyers. Any lawyer should have been able to find the same defence that Roberts found for his clients, and anyone charged with an offence should automatically receive the support of such lawyers. It's always tempting to dismiss such examples from the past as being in the past, suggesting it's something that doesn't happen today. Wrong. As I write these words, a lawyer by the name of Nick Freeman, who rejoices in the title Mr. Loophole, has earned his fame by winning court cases for celebrity clients charged with various motoring offences. Offences with which poorer people are convicted in staggering numbers every single day. Almost needless to say, Mr. Loophole doesn't come cheap. But the principle is exactly the same as that which existed in the days of W.P. Roberts and the Chartists. Those who can afford to pay for the services of a Mr. Loophole find their charges melting away. Those who can't are either hit with massive fines or go to jail. There have been several half-hearted attempts at providing affordable justice for ordinary people in the past, such as the creation of employment tribunals, for example. However, the legal profession quickly pounced on these so-called lower courts, so that today a tribunal is usually little more than the first relatively cheap step in what can go on to become a normal and very expensive legal procedure. It's not beyond the wit of man to provide affordable justice for all. It's simply beyond the desire of the lawmakers or of our trusted leaders to do so, because they're the main beneficiaries of the existing system, which pays them far more handsomely than a state-run system would. So what we have is a system of so-called justice, where those who can't afford the cost of a lawyer are forced to pay crippling fines or go to jail, whilst those who can afford lawyers often do not even see the inside of a courtroom. Terrible though the situation undoubtedly is, it's better than what exists in the US, the ludicrously self-appointed champion of freedom, where those who can't afford to defend themselves properly in court are not only treated as slaves as part of a thriving prison industry, but are sometimes also tortured and even murdered by the state. If it wasn't so terribly serious, the persecution by the state of those who can't afford to defend themselves would sometimes be so funny that if it were made into a film, we would dismiss it as a ridiculous farce, which in truth is exactly what it is. Consider, for example, the following story, which illustrates the enthusiasm displayed by the bureaucrats of the Crown Prosecution Service in their tireless devotion to providing justice, if they think they might have an easy conviction. On the 7th of October 2006, 2 workers at Morrison's supermarket were sacked for allegedly stealing some fried chicken to eat in their tea break. The missing chicken swag was valued at £1.84, so the Crown Prosecution Service naturally thought that a criminal prosecution was entirely appropriate. 5 appearances before Manchester magistrates followed before the great fried chicken thieves eventually arrived at Manchester Crown Court. The judge, showing the common sense that should have prevailed from day one, threw out the case with a scathing attack on the Crown prosecutors. An alleged theft valued at £1.84 was reckoned to have cost the taxpayer £30,000 in legal costs. This story, similar to countless thousands, perhaps hundreds of thousands of other so-called crimes in the history of what passes for justice in Britain, only lacked floggings and transportation to the colonies. At the other end of the spectrum, we have the super-rich, who have always been very favourably treated by our judicial system. Possibly the most obvious, well-known examples of this are displayed in the tax system, a system which ruthlessly persecutes any ordinary citizen who slips up on their tax bill, but which actively helps the super-rich avoid paying tax altogether. The examples are truly legion, from the likes of the Murdoch Empire to Philip Green, to Amazon and Starbucks and many, many others. A huge sector of the economy, the so-called offshore banking industry, exists almost exclusively for the purpose of helping the super-rich to avoid paying tax. And this tax evasion by the super-rich, which costs the state many billions of pounds every year, is a relatively minor crime compared with some of the other crimes routinely committed by the super-rich. The most abominable example of which is their fondness for and perpetuation of permanent war. War has always been about generating huge profits for the super-rich, and nothing better encompasses every obscene crime imaginable in one grotesque event than war. However, the super-rich never even do any jail time for these major crimes. There's nothing new in any of this. It's always been like that. Voltaire, for example, wrote the following about the gulf between justice for the poor and justice for the rich. It is forbidden to kill, therefore all murderers are punished, unless they kill in large numbers and to the sound of trumpets. The law is supposed to provide security for ordinary people. Ordinary people pay for it, so ordinary people should be the primary beneficiaries. The law is not supposed to be about enforcing elitist power and generating income for super-rich corporations and predatory lawyers. Where the law conflicts with common justice and our individual liberties, it must be confronted and reformed. So, given the obvious failure of our so-called judicial system, let's consider some of the particular flaws in the way it works, flaws which produce this situation. One of the most common well-known flaws is the practice of not paying magistrates. Magistrates dispense so-called justice every day of the week via hundreds of magistrates' courts. The custom of not paying them is a throwback to the medieval system of what passed for justice, where wealthy landowners presided over legal disputes and used the legal authority gifted to them by the state to help exert their considerable power over commoners. These people didn't need paid salaries, as the system effectively provided them with a license to extort money for themselves in any number of creative ways. Today, however, the practice still continues, so that all magistrates are effectively voluntary workers who only receive payments for incurred expenses, which is a bizarre counterpoint to the enormous sums paid to other practitioners within the legal industry. Many magistrates do not have backgrounds in the law, and therefore do not know much about it, and, because the position is unpaid, often do not need to work for a living. Naturally, this restricts the type of person appointed. Quite apart from administering what passes for justice in thousands of lower courts, magistrates have another, less obvious, but very important function. They legitimize many of the terrorist actions of our police. In December 2008, for example, a quite common event occurred. The police smashed down the door of a woman's house and ransacked her property, looking for evidence connecting her with suspected drug dealing. They found nothing. The woman, a single parent who needed to hold down 3 part-time jobs to survive, hardly conformed to the stereotype of your typical drugs peddler. Initially, there was not a single word of apology from the police, or mention of any compensation for the destruction they had caused, because, according to a police spokesman, their action had been lawful, meaning a magistrate had signed a bit of paper legitimizing the raid, in much the same way that the murder of Jean-Charles de Menezes was deemed by the legal establishment as not unlawful. That someone should authorize police raids is obvious, but the fact that people who do so, magistrates, are exonerated from any inquiry into their action when these raids are misguided, which is frequently the case, is a significant weakness of our judicial system. No tyrannical despot ever acted illegally, and no stormtrooper doing the dirty work for despots ever acted unlawfully. There were always a plentiful supply of complicit judges and magistrates on hand to casually sign the bits of paper that legitimized these terrorist attacks. Our society presides over an incredibly serious disconnect between what is legal and what is right, with our law enforcers and administrators seemingly oblivious of any difference between the two and completely unaware that what is not illegal is not necessarily right. It would not be difficult to stop this gross abuse of power, or at the very least, considerably reduce it. All that would be needed is to hold to personal account those who commit these outrages, the individual police officers who gun down innocent electricians, bash the brains in of harmless protesters, and run around smashing up people's homes, together with the magistrates who license all these actions. This would not be difficult to do, but of course it doesn't happen. To the best of my knowledge, no magistrate has ever been held personally accountable for licensing an unjustified police raid that has vandalized someone's home and possibly caused injury or death to innocent occupants.